Hello, my name's Jim Dunn. I've been a family lawyer for more than 30 years and a collaborative lawyer for 5 years. I've seen many changes to the way family law is practiced in Australia. My clients always ask me what is the best way of resolving the issues that arise after a separation. After a lot of thought and experience over the years, clearly the best way is direct negotiation and an agreement. But that's often very, very difficult because of the emotional hurt, the complexity of the case, the difference in the bargaining position. It is only on the rare occasion that a couple can negotiate all the issues that arise during their separation without outside assistance. A word of warning though, sometimes when parties reach a negotiated settlement themselves, the agreement ends up being very unfair to one party or the other. My view is that the best way to organise a separation is through a process known as collaborative law. Now, why do I say that? The first set of reasons I'd like to give are the negatives. That is, what's wrong with using the traditional approach. Traditional family lawyers rely on explaining what your rights are. These are the rights which are set out in the Family Law Act or by judges who have interpreted what the Family Law Act say. Such rights often have little to do with your life and what you're trying to achieve. The additional problem with the traditional system is that traditional lawyers must always have their eye on court. Although they say they're trying to settle the matter, they know that under this traditional system, court is the end result. Therefore, they must protect you, make sure you don't say the wrong things, keep their cards to their chest. It just isn't the right way to promote a settlement. The proof of why it is silly to prepare clients for court is the fact that only about 5% of cases that actually start in court are decided by a judge. This means of all the separating couples in Australia, a very, very small minority actually need the court system. One of the linchpins of the traditional system is the private solicitor-client discussions. That is, most of what happens in the traditional system happens in my office behind closed doors. This can only engender more distrust and lack of confidence in what your former spouse is doing. Having just discussed the problems with traditional family lawyers, you might be asking yourself, why do I need a lawyer at all? The first reason is because I have found, and other family lawyers have found, that there is a knowledge and power imbalance in most relationships. As an example, one party to a relationship is probably more involved with the children, and therefore, coming into a separation, that party has more knowledge, more power in relation to the children. On the other hand, one of the parties probably has more information, more knowledge about finances. So that party comes into the relationship breakdown in a more powerful position than that. So if there is this power imbalance that I've spoken about, your lawyer is there to advocate on your behalf, for you to talk to, for you to feel confident in, to ensure the right solutions are put forward in relation to those matters on your behalf. Another important role of an advocate during a separation is to help guide you during those very emotional times. During a separation, we would all become angry and do those things that normally we wouldn't do. Having an advocate there to guide you, to support you, and to show you where perhaps you might do something differently is vital in getting a settlement that truly sticks and is one that you will be happy with in the end. So what are the positives of collaborative family law? Collaborative law is a process in which the parties and their lawyers meet in open, four-way meetings, having contracted not to go to court. This is a very powerful tool. The advantages of this are that in the four-way meeting, you are there to hear what your former spouse says. Your lawyer is there as your advocate to help you understand what your real needs are and how we might achieve them. Information can be gathered in that process and questions asked. Collaborative law allows for creative solutions. We're not shackled by the old legal remedies. We can work out solutions which are tax effective, which are financially advantageous to both sides. We can also bring in child experts who might help us come up with a creative solution which is truly advantageous for your children. in the end, it really is a process that I would commend to you.